This tutorial, Understanding Regulations in Administrative Law, is closely related to our course on administrative law. Where the administrative law course covers substantive and procedural administrative law, here we focus on the nuts and bolts of how the agency materials published in the course relate to each other and create law. There are several different administrative materials that the skilled legal researcher needs to master. What are administrative materials? Administrative materials are made up of any published information generated by a government agency in the course of its work. This tutorial will focus on these agency-created documents. To understand where administrative materials come from, let's take a look at some examples. The Constitution gives Congress the power to lay and collect taxes. Congress created the Internal Revenue Service, or IRS, which is an agency located in the Treasury Department of the executive branch. The IRS handles the day-to-day details involved in processing tax returns and performing audits. The IRS produces a wealth of helpful secondary sources. These advisory materials include revenue rulings, revenue procedures, notices, and announcements. Agencies can only do what they are authorized to do. Congress authorizes and directs the work of agencies through enabling legislation. For example, when Congress first passed the Internal Revenue Code, it created the Internal Revenue Service. Congress also delegated to the IRS the power to collect taxes, giving it authority to carry out the work Congress assigned it to do. The Internal Revenue Code is an example of enabling legislation. In this statute, Congress sets the amount of the tax and directs the IRS to figure out how to collect the money. Congress also creates agencies when special expertise is required to govern technical or scientific fields. The average American and the average legislator knows very little about nuclear physics. So Congress created the Nuclear Regulatory Commission and provided that it hire nuclear physicists and engineers to create standards for the construction and operation of nuclear power plants and to ensure that those plants are operated competently and safely. These standards are also called regulations and become part of the larger body of administrative law. Agency powers mirror those of the three branches of government: legislative, judicial, and executive. Regulations are similar to legislation. Adjudications, like judicial trials, provide an opportunity for a formal hearing. And the executive function can include the power to investigate wrongdoing and enforce laws and regulations. The enabling legislation determines which among the three powers a particular agency can exercise. One of the most important forms of administrative material is a regulation. Regulations permeate many aspects of modern life. From the nutrition label on a can of food, to the label on a car's sun visor, to the copyright warning at the beginning of a streaming digital movie, regulations affect everything. Regulations have the force of law because the enabling legislation delegates rulemaking power to the agency. Regulations are valid until the agency changes the regulation, the enabling legislation is amended or repealed, or the regulation is struck down by a court. Some regulations are promulgated with a sunset provision that defines how long the regulation will remain in effect. There are a variety of ways to create regulations, which are covered in detail in our rulemaking clip of the administrative law course. In the next clip, we'll examine in detail the process called informal rulemaking, which is the method most commonly used. Now that we've covered what regulations are and where they come from, let's talk about where to find them. The need for an official administrative publication became apparent in 1935 when the Supreme Court, in the case Panama Refining Company v. Ryan, issued an interpretation of a regulation that was no longer in force. This embarrassing situation led to the creation of the Federal Register in 1936. The Federal Register is the single most important administrative publication. The Federal Register is a daily publication of the federal government and functions primarily to provide a place for agencies to officially publish their proposed and final regulations. In addition to proposed and final regulations, the Federal Register also includes notices and presidential documents. Notices are non-rulemaking documents. Notices can include announcements of public meetings, hearings, investigations, grants and funding, and environmental impact statements. Presidential documents include proclamations, executive orders, and other communications. The most significant presidential document is the executive order. Presidents issue executive orders to clarify or enforce existing law, or set government policy. A companion publication to the Federal Register is the Code of Federal Regulations. Whereas the Federal Register is a daily journal of proposed and final regulations published as they are promulgated, the Code of Federal Regulations, called the CFR for short, constitutes a comprehensive compilation of all the regulations currently in force at the time each title is published. The CFR represents a moment frozen in time. Any regulation it contains could have changed the next day. The Federal Register is to regulations what the statutes at large is to public laws. The CFR is like the U.S. Code, as they are both arranged by topic. In addition to rulemaking, a second important administrative item is an adjudicative order. Agencies can hold adjudications and issue orders, thus performing quasi-judicial functions. Sometimes these hearings are held by administrative law judges, also called ALJs for short, appointed by the agency. Sometimes the full agency governing board hears the case. For example, the Environmental Appeals Board, or EAB, is a body within the Environmental Protection Agency, which you probably recognize by its acronym, the EPA. Members of this body hear appeals from decisions issued by EPA ALJs. EAB decisions can be appealed to the federal courts. Typically, these adjudicative orders, which read like judicial opinions, do not appear in the Federal Register or the CFR. Agencies issue all kinds of other types of orders, which do appear in the Federal Register. In addition to regulations and orders, there are a wide variety of additional administrative materials published by agencies. These include fact sheets, brochures, posters, notices, handbooks, and statistical databases, to name a few. You've probably seen the Equal Employment Opportunity Commission, or EEOC's Equal Employment Opportunity is the Law poster on a bulletin board. Less well known is the National Highway Traffic Safety Administration's National Automotive Sampling System database. It collects car accident data from police reports and is used by scientists and engineers to improve vehicle design, making cars and trucks safer. While agencies produce all kinds of information and publish many different types of documents, only final regulations and orders have the force of law. Any other agency material is considered to be a secondary source. That's a lot of information to cover all at once, but you should be feeling much more comfortable with the types of administrative materials produced by various agencies. Remember to stop and take our quiz on this clip before moving on to our next clip on regulations and the informal rulemaking process.